Hello and welcome to Siam Center Law Group podcast today. We're going to talk about a small but incredibly important technique for fighting a legal case in court, specifically the witness examination stage. Whether you're a lawyer or just an ordinary person involved in a case, understanding how to present and weigh evidence can make a real difference in the outcome. Here are four simple yet powerful techniques to help you navigate witness examination and strengthen your case. Technique 1. Preliminary review of the facts and evidence. The very first step when entering any legal process, whether it's a pretrial inquiry or filing any kind of motion, is to review your facts and evidence. Do they seem plausible? Is there a reasonable basis for your claim? You don't need to have 100% solid evidence at this stage. If the facts and witness testimony appear credible on the surface, even if it's less than 50% convincing, the court may still allow the case to proceed. The key is to present something that points toward the truth, even if it's just a preliminary indication. Technique 2. Weighing the evidence in civil cases. In civil cases, it's all about weighing the credibility of each side's evidence. You don't need to completely outmatch the other side. You just need to show that your evidence has slightly more weight, even by 1%, and that can be enough to win the case. It's not about overwhelming strength, but about comparative credibility. Which side seems more believable or reliable? That's often the tipping point. Technique 3. When asking the court for a unilateral order or where rights are strongly affected. This technique applies when filing motions that can seriously affect the rights of others, or when you're asking the court for something without notifying the other party, such as an urgent search warrant or property seizure order. In these cases, your evidence must be clear, strong, and credible. The court must be convinced that your request is not only justified, but also supported by solid facts. Weak or ambiguous evidence can cause the court to immediately deny your motion. Technique 4. Criminal cases require evidence beyond a reasonable doubt. Lastly, in criminal cases, the bar is much higher. Evidence must be beyond a reasonable doubt. Even if you have a large amount of evidence, if there is still a reasonable suspicion that the accused might not have committed the crime, the court will not convict. This reflects a foundational principle of criminal law. It is better to let 10 guilty persons go free than to convict one innocent person. So in criminal trials, you must prove with clarity and certainty that the accused did commit the offense. No lingering doubts allowed. By recognizing the different strategies needed in each type of case, you'll be better prepared to fight effectively and present your evidence in the strongest possible way. Understanding what the court needs to see at each stage can be the key to winning a case, not just with facts, but with strategy and precision.